over.
People get
All right, we are recording. We're ready.
kinds of be mixed up with each other a lot.
They do. They do. Absolutely. Yeah. Yeah. You know, absolutely. Trademarks versus copywriting, and even like the ownership, and you know, like that stuff's. Yeah. I don't.
Go ahead, yes, sir.
Yeah. You good? Yeah. Go ahead, Corey. Do you have an announcement, Corey? I'll introduce you.
All right, everyone, we'll now begin the lecture. Sorry, a few technical issues, but mostly been sorted out. Well, you will always on next program. As a reminder, if you do have any questions or anything like that, make sure you bring in your hand, say your name, so I can log down to the letter question again. Make sure you sign in so you're all of that stuff.
Thanks, Corey. All righty, folks. So I'm really excited about today's seminar, colloquia, and our guest speaker. I don't really need to look at this for much, except I want to get a couple of things, dates right on that. So it's my absolute pleasure to introduce today's speaker, Dr. Vanessa Lancaster. And I don't, do I say doctor? I have no idea how to introduce her.
No.
We'll learn part of that. And so you'll find out. I know Vanessa very well. We were grad student lab mates together. It wasn't that long ago. Okay.
He's in the laser room and I was with all the protein and the bacteria. So it was like a delineation for that.
But share that same cubicle space office, right? That 4-person cube space office. So yeah, we were where you all were, including space. But Vanessa, she did her bachelor's in chemistry, biochemistry at UC Riverside, and then went to ASU where she worked with Bob Blankenship, same as me, graduating with a Ph.D. in chemistry, emphasis in biochemistry, and then, bless you, formed a postdoc with Dr. Bert Jacobs there at AZ Biodesign Institute, and then went on to get a law degree on the Sandra Day O'Connor School of Law at Arizona State University, so double Sun Devil. And has been a practicing lawyer since 2009, and so now is a intellectual property patent lawyer with McKee, Voorhees, and Sease. Is it Sease? Yeah, Sease and in Phoenix. So I've been wanting to. Vanessa and I've been talking for a long time. I gotta have you come talk to our students because this is an area that we know nothing about, and you know how we're always trying to promote jobs, opportunities, career paths that we may not often consider. And so this is an absolute privilege, pleasure for us to have you. Thank you, Vanessa, and I'll leave it to you.
Thank you, Gabe. So I have to say it's really cool that Gabe and your department does this for you. It says we were discussing this morning when we were graduate students and undergrads, we didn't know anything ever. Like you just stumbled upon careers, So I didn't know anything about scientists in law school. That's ridiculous. What the hell would law want anything to do with scientists? Well, there's an entire field, just like there's an entire field of research, which I also didn't know existed until I became an undergrad. So I was always into science and math as, high school and everything. And so that's what I majored in college. And then college showed me there's this entire universe of research, academic, private, commercial, government research that exists that all these scientists go into. I didn't know any of that. And then when I was in grad school and then trying to figure out what to do with my life, I found out that there's a whole career for scientists in law. And if I wanted to become a lawyer, I didn't have to leave my PhD and my beloved, love of science behind to do this other really interesting career. So it's really nice that you are being shown this instead of you stumbling upon it the way I did. It doesn't leave a lot for planning, when you're just kind of stumble into things. And I'll give you the story of how I stumbled into it. So that said, yes, this is my law firm. We are based, I have a laser pointer too. We are based in Iowa. I work remotely. I live in Phoenix. I worked at a boutique patent law firm in Scottsdale in person for about 10 years. And then I was hired by an intellectual property firm in Minnesota, and now I work as senior counsel at McKee, Voorhees, and Sease. And I do science every day. And I have to understand, all the data and inventions as well as a lot of legal issues that my clients need. And my clients are a lot of universities, the IP managers that I work with at universities and the professors directly, and companies. That's pretty much the two types of clients. So because I hadn't even heard of patents when I was an undergrad or a grad student, I'm just going to give you a quick overview of what patent law and patents are and intellectual property is. I'm not intending it to be like an intro to some boring kind of law that you don't want to hear about. Okay, so it might not make a lot of sense what about my career to tell you about if we don't just cover a couple things about intellectual property. No, I have to do this.
Sure.
I think I'm just faced the wrong way.
Might have to like press the button.
Which button? There's buttons everywhere. Okay,
What's this?
so one of the first things to know about intellectual property is there's 5 different kinds.
Okay, sure.
We got patents, copyrights, trademarks, trade secrets, and contracts that govern all of these things. Okay, so I work mostly in patents. I've done a lot of trademark as well. So patents are going to protect any new useful invention, and we'll talk about that. And trademarks are going to protect the name of the source of any goods or services. So one of the best trademarks is Apple computers. It's a great trademark because the word Apple does not describe computers in any way, shape, or form. So that when you get an Apple computer, you know what you're getting because you look at the reputation of that company. So that whole source of goods and services is really big in trademarks. A lot of litigation around trademarks. People fight like crazy over their names of things, like you wouldn't believe. So lots of work to be done in there. Copyrights protect original works of authorship as soon as it is affixed in a tangible medium. So as soon as you code it in the computer, as soon as you put it on film, any kind of tangible medium that you own that copyright. And there's obviously a lot of, I always think of Disney. Our law school books on copyright are like full of cases by Disney. So, yeah, copyrights give you an exclusive right to reproduce, distribute, copy your own work, display the work, perform the work. It's really about original works of authorship. So trade secrets, popular trade secret. Can anybody think of like, maybe a trade secret that's, huh? Coca-Cola, that's the one I always think of too first, Coca-Cola recipe. So trade secrets are, beer, maybe. Yeah, that originated protection for trade secrets in I had to write it down, the Economic Espionage Act of 1996 and the Defend Trade Secrets Act of 2006. And really, trade secrets is about protecting information that is valuable because it is kept secret. And a big part of that is are reasonable steps taken to keep it secret. So if someone's, if the Coca-Cola company is putting their recipe out on the internet and it's really easy to find, then they don't get to keep that trade secret. That's, public now. And contracts, I work a lot in contracts in each one of these things. Contracts can be employment agreements that transfer your rights in any patents or trademarks or copyrights or trade secrets to your company. License agreements between companies and universities and between companies and all kinds of parties. So you can have intellectual contracts that are all about intellectual property or contracts that have like a part of it is about intellectual property. So another one that you might have heard of are non-disclosure agreements. So when two parties are getting together and discussing, hey, do we even want to work together? Well, we have to discuss some confidential stuff to see if we even want to work together. So you have, an NDA before you even start talking.
So that would never fall under contract.
That would fall under contracts. Yeah, you can sue under violating an NDA. So lots of tricky things about that because not all companies, especially if they're a big fish, mind NDAs that much. So you have to be careful. So
They all have good lawyers to get around.
probably, yeah. Yeah, there was is it Barton Ski? They make ski boots and stuff. Yeah, they had the fitting that attaches the boot to the ski, and they were talking to a company under an NDA about that, and Bart said, "We really like your fitting, but we don't want to, actually let you make money, and we're just going to put the fitting on there." It was a big lawsuit about that, and they just ignored the NDA. Because maybe they make more money by stealing it than they do defending the NDA. So just real quick, well, maybe not real quick, the origin of patent law actually comes from our Constitution, Article 1. And there's a patent clause in there about the Congress has the right to protect, promote the progress of science and the useful arts by giving a limited amount of time of exclusivity to those inventors. So it's actually embedded in our Constitution, which I think is pretty cool. Lots of rights obviously aren't. And it was codified in 1952 in Title 35 of the United States Code. That code is usually what I quote when I'm making arguments and things. So the Constitution is like everything else, it's really vague. So the code is actually lays out what the rules are. So the U.S. Department of Commerce houses the U.S. Patent and Trademark Office. These are the guys that I deal with every day, I argue with. They're full of patent examiners. I didn't even put that on another possible, you can be a patent examiner. Because, I deal in cell molecular biology, biochem, chemistry, organic chemistry, and all the patent examiners that I deal with, they're all from that background. They have all these different art units. And so they have, taken the patent bar, received a lot of training through the PTO. They live all over the country, which is really cool. That's another kind of remote thing you can do if you really want to, have your job and live in Costa Rica or something. And patent examiners tend to be pretty good scientists most of the time. Okay, so just a couple basic things about patent rights. You get 20 years of exclusivity for your invention if you get an issued patent in exchange for making everything in your patent public. So we were talking earlier about lots of movies get patent rights wrong. Like there was a Marvel movie where Iron Man or someone was saying, I've got my invention locked up in the patent office, in the vault of the patent office. That's the opposite of what patents are. So patents are an exchange between you and the government. I'm going to tell the world what my invention is so that other people can build off of it, and we drive innovation, drive science, drive commercial interest and all that. But in exchange, I get to have exclusivity to what the claims that are issued in my patent for 20 years. And interestingly, it's this exclusive right is a right to exclude other people from making, using, selling, or importing your invention. You don't have the right to make it. If you try to, if you patent a new kind of heroin, I don't know, a new kind of, explosive or something, you don't have the right to make that and sell it just because you have a patent on it, right? So it's a right to exclude others from making, using, selling, or importing. You might be able to patent that, and then, some company will license it from you, and that lets them go off and make it if it's legal to do so. So interestingly, you cannot patent anything that whose sole purpose it is to be used in nuclear weapons. I thought that was kind of cool. So you can't, anything that's only used as to be nuclear material for atomic weapons and things. There's actually an act in Congress, or, an act that you can't patent. So not that will interfere with our lives, but I think that. So what is patentable? It comes down to, is it useful? Most things are, so that's a pretty low bar. Is it new in view of what's been done before? So that's a novelty requirement. And is it non-obvious in view of what's been done before? And that third one is always our hardest hurdle when we're trying to get a patent. So the examiner gets to gather many different scientific publications, other patents. Somebody has a PowerPoint presentation on the internet, a poster from a conference. I had a thesis from a student in Germany once cited against my patent. They can take it from anywhere, as long as it's published before you filed your patent application. It was not. Yeah, I don't know how that examiner even found that. It must have been state. But the examiner can say a person of skilled in the art, which is all of you, would look at these 6 different references that they cited from all these different sources, and they would put it together and arrive at your new invention. And you have to argue many areas of the law which say that's wrong. I'll be polite. That's not true. So, and then there are judicial exceptions, meaning that the courts have carved out certain things that are not eligible to be patented. Laws of nature, abstract ideas, natural phenomenon. So mathematical formulas fall under that. Things that just anything in nature. There's some famous cases out there like isolated DNA. Well, that DNA appears in nature. You can't patent that. But if you, make it cDNA, then you can patent it. So
Are the examiners lawyers too?
no, they're very often patent agents.
Okay.
And we'll talk about that. That's someone that's passed certain requirements, but they're not an attorney. Let's see, and I guess the last thing I'll tell you is 4 categories of patents that are issued: compositions of matter, processes, methods of manufacture, and machines. So processes, methods of making various things, and compositions of matter are mostly what I mean. So any questions about that? Just kind of what patent is? I think I put a picture of a patent up here. Well, that doesn't look great, does it? Read that at all? So this is a patent I got issued this past March. So this is just the first and the last page. This is about 160 pages, I think, this patent. So it gives you the title. This is the first name inventor. There's the patent number and the patent date. Who owns the patent? Its initial application number, all kinds of data here. All kinds of publications that are cited, my abstract. And really, what you own when you get a patent at the very end are the claims at the end. So each claim is one long sentence, and this is what you own. When you file a patent application, you have one set of claims. Invariably, what you end up with if you get an issued patent is a very different set of claims. So your patent can say, 100 different things, but maybe you only get 6 things in your claims actually get issued. So just because you write into a patent, you don't have a patent on that. What you actually own, like your title, is what's in these claims at the end.
When you license one, do you license a specific claim or do you license the entire patent?
Well, so a license is a contract, and there's more or less freedom to contract, and that contract can be anything the parties agree to. So you could carve out just one part of, exclusivity, and the rest of it is non-exclusive. That's not too common. Usually they want the whole patent. And you can buy and sell patents too. So licensing is more common because, it can be more lucrative, but some people don't want to deal with that. They just want to sell it. So any questions so far? Yeah.
I see that there's a patent number, but is there any way to keep track of any one person that might have a patent?
Absolutely.
Or
We do it all the time. Yeah. Sometimes there's rogue inventors that go off and start their own thing, and they, their original company really owns what they continue to do. So we keep an eye on them, So the patent office has its own search engines, and Google Patents too actually is really useful. And then there's proprietary software that does all kinds of different patent searching, and you can search for just literally anything, and you can put patent alerts, like have certain criteria, and this patent alert search engine will just continuously search, and if it finds something, it emails it to you. So
just wondering, if you patent something and it says only United States, it's only like, I don't know, is it different for a while than United States, or you have to patent every country that you want it?
it's a great question. Yes, patents are country by country. So this is the United States patent, but I believe it has other patents pending around the world. So I won't describe the workflow of going international because it's kind of too long for this. But yes, most every country has its own patent office, but there is a treaty called the Patent Cooperation Treaty that makes everybody cooperate. So it was a part of this treaty, which is most every country. Meaning you can file in one patent office and they give you a certain amount of time to file in all of them, where they will, best word, where they will honor, maybe that's a good word for now, they'll honor that first patent application. But you have to go through a separate exam process in every country. So, and there are some regional patents, like there's an EU patent for, all EU member countries. It's an expensive patent to get, but a great patent. There's a few smaller regional patents like that, but for the most part, you have to, like in the UK, you have to, there's that one office now. That's not part of it anymore. But yeah, it's a whole international thing, and that can easily, prosecuting patents in all those different patent offices can easily get into the millions of dollars. So the IP managers, like at universities, really pay attention to, what's the commercial interest of this patent application. When you get to the stage where you need to start making decisions about what countries to file in, it's like, well, where are our customers going to be? Where's our manufacturing going to be? Where are we going to have the most sales? What makes it worth it to spend the money to go after patents in all these countries? So it's very much a business decision about where to file. But it's good to know beforehand because it does influence the way that you draft these things. All these different countries have different requirements for what has to be in the patent application. Okay, types of patent practitioners. I'm a patent attorney. I mostly do patent prosecution, meaning fighting back and forth with the USPTO. There's also patent litigators. They don't have to be patent attorneys. So as I'll talk about later, a patent attorney is an attorney first. So went to law school, passed the bar exam, and then I took the USPTO patent bar, which is another exam, and got a registration number from the PTO, and that's what makes me a patent attorney. So it's, this bar exam for your state that all attorneys in the state have to take, and then the patent bar is provided by the USPTO, and it's the worst exam. I'll be honest, it's the worst exam you will ever take. I've taken hundreds of exams probably. Sure, you all have too, but it's by far the worst exam. So I'll say the state bar exam, you have to know a lot of material very shallowly. You have to know a little bit about everything so that you can issue spot things. The patent bar, you have to know this narrow amount of material, just A to Z, so deep. So it's a very different kind of horrible exam. So
Is the test with more than multiple choice, like tried it?
yeah, they even give you the manual patent examining procedure, the MPEP, which is a manual. They let you have that during the test, so it's open book.
It is,
But the real book, and it's timed, yeah, it's horrible. So when they finally sent me my certificate that people put on their wall, I still haven't put it up because it makes me angry. Look, it's.
My question is that federal, state specific, like patent law for specific states or federally recognized if you have the exam.
So, good question. So patents and patent law is all federal law. So that's really nice because you can, as long as you're licensed, as long as you have a license to practice law in the state that you're living in, you can practice patent law there. So you don't have to have, you don't have to be a licensed attorney in multiple states or anything. So the law firms will require you to just have pass the par exam and, be an attorney in the state that you reside in, but it's all federal law.
You mentioned that you work remotely for a firm at somewhere else, so are you in the state of Arizona as far as that, or?
So, right, so I practice in Arizona, I'm licensed as an attorney in Arizona, but my firm, my previous firm was in Minnesota. Well, my first firm was here, but then my previous firm was in Minnesota, and this one is in Iowa. But yeah, because I'm 14 years of experience now and I don't need, supervision anymore, they let those attorneys just kind of be wherever they are. But I would say for like the first 10 years or so, law firms will want you to be in person there for training meetings. Patent litigation. So we were having this conversation earlier. Litigators are different animals completely. I am a transactional attorney, meaning I read a lot, I write a lot. I argue with the PTO on the phone, via Zoom if it's an appeal, and in paper a lot. So, a lot of what I do is at arm's length, I guess you'd say. Litigators are in court, they're in person, they love to argue. They don't care what they're arguing about, they're just argumentative people. They're very smart, very quick on their feet, they're just different people altogether. Patent litigators don't need to be patent attorneys. If they're litigating, a challenge to a patent, I think it would be helpful if they were patent attorneys, but they are often litigators that are just damn good litigators that are working with a patent attorney to make sure that the patent law part of it, which is a huge area of law, is done right. So the patent attorney might do a lot of the writing, but that animal litigators up there doing, the stuff of, the persuasion part in court. So I've worked with patent litigators before, and it's kind of a mixed bag whether they're patent attorneys or not. Do you have a question? Okay, so we're talking about your types of patent practitioners. So one is patent attorney doing patent prosecution before the PTO. You have to be a patent attorney to do that. You have to have that patent bar passed. Patent litigation, you can be an attorney, or you can be a registered, registration with the patent office or not. And then patent agent. So this is where you're not an attorney, but you've passed the patent bar with the PTO. This is a really good career. You often work under a patent attorney. You can represent applicants before the USPTO. I work with the most amazing patent agent. He got his name's Charlie Romano. He got his Ph.D. from Harvard in chemistry, and he worked for Monsanto for like 20 years. And he is an incredible patent attorney. I mean, he's treated as equal as a partner. He can't be a partner in the law firm because he's not an attorney, but he's treated that way, and he's definitely senior to me. So, because he knows the science so well, and he's worked with the PTO so long, he's just incredibly skilled. So they cannot give legal advice. They have to stick, they have to stay in their lane. And I think, when I was first thinking about law school, or becoming a patent agent, I kind of felt like I wanted to go all the way. I wanted to do the attorney part, because there's a lot more flexibility, and clients have a lot of issues. They might need to patent something, but they're also going to have, contract issues like employment issues, patent ownership issues, issues with the inventor, inventorship, ownership issues, business issues. You got to be able to issue spot and tell them, here's the thing, here's the issues I see. I can help you with these three things. I'm going to send you to this other guy for these two other issues that I don't normally deal with, but he's really great at that. The clients don't, I suppose it's sort of like when you go to the doctor, it's sort of like medicine where patients, come in with a number of issues and you have to be able to see that. So I think that is a limitation for patent agents. It's a limitation I didn't want, but in order to become a patent agent, all of you can become patent agents if you just study for the patent bar and pass it, because all you need is a technical degree. If you already have your undergrad in physics or chemistry or whatever, you already qualified to take it. That's one of the requirements is a technical degree. And then you have to pass the horrible patent bar. So
So you don't need to go to law school.
you don't need to go to law school to become a patent agent. Right. So, you don't need a PhD. It's just the requirement is an undergrad technical degree or a certain number of hours. You know, if you almost got a degree, I suppose, or if, you know, you were a music major, but you did a lot of work and almost got a chemistry degree too, or something like that. You know, you took 40 hours of chemistry and you took 20 hours of physics, or, you know, they have a way of cobbling it together. But
Like
Yeah.
your friend and his expertise, as a subject matter expert working in his pen, he's got a PhD in biochemistry from Harvard, right? I imagine that elevates his status and also
Yeah.
his ability, just.
yeah, and just his insane amount of experience. So bench experience, and then at Monsanto, he became like an advisor in the legal department because they needed him, and he just kind of fell into doing this. And now he runs his own team at a law firm.
But advice, like say, can give legal advice, so it's still from more of the subject matter expert of understanding that field.
Well, he can advise anything before the PTO.
Okay,
So he makes legal arguments to the PTO,
okay,
but he can't advise on licensing. He can't advise on.
like this client relationship.
Right,
Yeah, I
right.
got
So
you.
he has to be careful there. So
Got you.
he'll bring me in to talk to one of his clients about like freedom to operate. So, you know, clients making something, they're worried about a competitor that has a patent. Am I okay to be making this thing because I'm worried about this patent? I come in and do that legal analysis to be like, no, stop making that, you know, or change it somehow, or, you know, are you infringing a patent? Anything like that, you can't do. So it is a limitation. And I should have put in here, PTO patent examiner. That should have been like number 5 down here. Another one is in-house counsel at a tech company. So, very often, in-house counsel at any kind of, I deal with biotech companies, so I keep saying bio, but, you know, any kind of technology company. Those attorneys will often be scientists as well, because they're listening to the science all day long, right? And they have to be able to advise on the direction of research, talk to investors, get grant money, you know, I mean, scientists are needed for all those roles, because you can't just have non-scientists come into that. They're gonna have no idea what they're doing. So in-house counsel can be very talented PhDs, whether or not they're attorneys. So it's always nicer when they are, though. So I always laugh in movies when they say, you're gonna hear from my attorney, you know, like as a threat. And it's like, please give them my phone number. I would 1,000 times rather talk to your attorney than you. You know, because your attorney is gonna understand, you know, the metes and bounds of the conversation and what everybody can and can't do, instead of being emotional about it. So it's always nicer when they're an attorney, because then you can have a productive conversation. So university IP managers, technology transfer development, sometimes they're attorneys, sometimes they're not. But they certainly deal with patent attorneys all the time. My job is very often working with university intellectual property managers. They have a really tough and interesting job. I think I would have liked that route a lot myself. They're the first person, you know, a professor like Dr. Montano would see when he wants to go get a patent, and they determine what at the university gets patented. You know, do they have the funds? Does the patent, they might go out and find licensees for it. You know, is there any commercial interest? And then they call me up and say, okay, we want to file a patent application on this. And then they hook me up with the professor, and I get my writing done, and we submit the application. And then they're in charge of all of the lots of steps of prosecuting that patent through the PTO. So they're a constant, you know, contact for me that I deal with all the time. And there are always scientists, because they, you know, I very rarely run into one that isn't, and they're very ineffective when they're not. So universities know that they've got to have good scientists being IP managers. So if anybody's interested in that, I wouldn't hesitate to walk in to your IP managers here and be like, hey, are there any internships here? Are there, I know people who have gotten in it that way and they have a good job coming out of the school. So the university IP managers is a good deal. That one of my favorite ones is a patent attorney, Michigan State University. He is awesome. So I think, inputting law into this makes you more effective, more versatile, more job availability in different institutions, but it's not, 100% necessary either. But I'm glad I did it too. Any questions about these different areas? This is pretty much most of what I can think of. So there's a lot of room for scientists, certainly in law. Okay, so general credentials. I put bachelor's, master's, or PhD in sciences or engineering. If you're in the bio part, I would say computer, Gaby taught physics, and electrical engineering for sure, and probably mechanical engineering. Just a bachelor's degree and a law degree to become a patent attorney is great. But if you're in biochem, chem, organic chem, probably material science, any of those sciences, the PhD is really where you want to be. So master's is probably okay, but I'll be honest, when I pull in associates to help me with my work, I won't give it to any of them that aren't PhDs because the data is too hard. What the professors and CEOs of these companies, like the data they're sending us, it's just too high level to, you need to hand it to someone who's going to understand what they're looking at and know what questions to ask. And it's just not something you can teach them. They have to go to school for that. So, so it's definitely been nice. I've never wanted for a job because I have a PhD. When I go to another law firm, but I wanted to switch a lot. There's the one time I really wanted to switch law firms from the Minnesota one to this one. It took me a month. So that's nice. So secondly, you got to pass the legal bar exam, patent bar, and then become a licensed attorney in the state that you reside in. And that's, of course, just for patent attorneys. For patent agents, you got to do the first two. So if you want to do the patent attorney route, the third one. And those are just what I personally did.
That's it. If you didn't have your PhD, how different do you think your job would be that you do now? Sounds like it'd probably be night and day. Like, so say you kept the BS straight to law school.
Yeah, that wouldn't have worked.
Yeah.
It really wouldn't have. I might be in like patent litigation, but you could do any kind of law. You go to law school and decide, you know what, this science stuff sucks. I'm done with it. And be like, I really like entertainment law. I want to live in LA and represent basketball stars or something. You can make that decision in law school and go a completely different route. But if I didn't have my PhD, I definitely couldn't do the work that I do. That's for sure. So, and the people that have given me work along the way wouldn't have done that either. Because, it kind of really starts with the science and the data. I mean, most of my inventor intake meetings are that inventor giving me a talk that they gave at a conference or planning to more like, or handing me their manuscript of something they're about to publish. And they're like, here, okay. So, these are people, they can't sit there and teach it to you. You have to understand, and then you're free to ask them questions about it because you're not an expert in what they do. You're just, you have enough knowledge to understand if you're handed something to read, you have to be able to figure it out.
Yeah, and that's a really important point because I just wanted to get across to y'all because like, I think it's oftentimes like, well, why did I get a PhD? I could have just gone straight to law school. That's another reason, right? But you would just be a lawyer, not a very highly, specified and have this work potential that
Right.
career potential that you couldn't otherwise. You could have done it also by getting a history degree going into law. There's been a
Exactly.
differentiation, right?
Exactly,
Yeah, I think it's a really
very
important.
true. I can talk a little bit about law school, like how next. Yeah, okay. So Gabe said,
Absolutely.
Tanya said I had to talk about my journey. Okay, so I just really liked science for the longest time. And so I just went for biochem at UC Riverside and was introduced there to the world of research. And I thought coming out of high school that if I liked science, I had to be a doctor, an MD. I thought that's, never heard of anything else that people that like science can do. But the people that were on the MD track at my school were people I didn't care to spend time with. It really turned me off of that profession just because I didn't like the nature of the group of people that were going that direction were pretty terrible. So I was really excited to find out about this whole world of research. And so I thought, okay, I have to become, a research at a university. So I went to grad school and, so we were in the lab together. And
So it was called.
that's what it was called, yeah. And so after that, I still didn't really know which way I was going, but I still really like science. I like being at the bench. So I went to what do you do next? You do a postdoc. Okay, let's go do a postdoc. So I went to the Biodesign Center for Infectious Disease and Vaccinology and made smallpox vaccines for like 3 years. That was super fun. And unfortunately, this was at a time where baby President Bush, the little one, was sucking all the money out of the NIH. And so the score you had to get on your grant went way up.
Yeah.
So if I had been in Clinton era, I guess would be, my grant would have gotten funded, but because they had less funding, that meant you had to have a higher score to get funded, and I didn't get funded, and that kind of introduced me to, oh, this is going to be tough. So, but then one day, the law school that was literally across the street, and this goes to my cluelessness about not knowing that this whole profession existed. The law school was having a conference about forensic science and the law. It's like, oh, cool. Everybody from infectious disease on my floor went over to the conference, and there was like a really famous forensic scientist there. He was, I think he's a Japanese guy. I can't remember his name, but he wrote like basically the textbook the FBI uses to teach forensic science, right? And I saw this big room filled with all these lawyers that were some of which were scientists, and asking questions, and scientists and lawyers all mixing together. I'm like, what the hell is this? So I looked into the law school, and they had a whole the Center for Law, Science, and Innovation, it's called now. When I was there, it was Law, Science, and Technology. And they wanted PhD scientists to get into the law school. They were building, their patent law and just law, science, and technology. They wanted to have a whole great department. Gary Marchant was in charge. I think he's still in charge of it. And they just wanted to get PhDs in. So I applied. I took the LSAT, which I did very mediocre on, like I've done, mediocre on every standardized test I've ever taken. And I got admitted, just because of my PhD. They're just like, come on in. That was great. And I took a lot of classes within that center, and they gave me a little scholarship that was nice. Yeah, I really just took to it. And law school itself, it wasn't hard. I mean, you guys are all used to hard, right? You're used to being busy, used to learning new things all the time and writing all the time. And law school wasn't hard, it was just very busy. I kind of, Sunday afternoon, like I take Saturday off and have fun Sunday. And I didn't have kids at that point though, but I was married. And right around 2, 3 o'clock in the afternoon every Sunday, it's time to start sitting down at my desk and, start reading for the week. And I tell people, I had to give up TV Sunday night through Thursday night. So, it was just very busy. And I actually continued my postdoc for the first 2 years, the first year of law school, because I wasn't done making a vaccine that we were putting into clinical trials. So I had to get special permission to do that from the law school, because at the time, they didn't allow anybody to work during the first year, because the first year is the weed out year. Everybody takes the same classes, contracts, civil procedure, just the basics of law. Do I have 15 minutes left? Okay. During that first year. So they don't want anybody working, but I got permission to do that. So I actually worked all the way through law school. I joined as a clerk at a patent law firm, as a technical advisor, they called me, for the last 2 years that I was there. So law firms will come to the law school to hire clerks, and do interviews there. So that's kind of nice. So, any questions about law school? I have it on the next slide that talks about cost and stuff like that.
You said that were you getting paid as a clerk or
Yeah.
any come through?
Like $25 an hour, not much, but, it made it so, the husband, paid for the house, and I was able to pay for my gas and food and books, so it wasn't a complete burden. I didn't have to take out as many student loans, so, it was nice to have a little bit of income.
Are there law schools that exist where, it can be paid for, so or even undergrad, a full-ride scholarship? Something that actually.
I believe so. When I first, on the orientation part of law school, a lady did from the financial aid came in, and there was definitely support for Native American, African American, people, unrepresented groups that, underrepresented in the law school. So that's pretty much all I saw though. So if you're interested in the law school, definitely ask about that. Those scholarships do exist. I don't think just, it used to be that just being female was okay, but law schools are pretty 50-50, men and women now, so that's all. So, but yeah, there for certain groups, there is. I've heard of companies, sending their people to law school, but I think that's pretty rare. So law school is definitely an investment, time and financially.
I assume it pays off.
It did pay off, and I am glad I did it, yeah, but it's, it's expensive, it is, and it takes a while to pay for. Unless you got that trust fund, we all have, right? So then the bar exam, that was kind of fun, actually. It's the 2 months right after law school. So you go to graduation, went to Vegas, I think. My husband had some fun. And then 2 months of total immersion in the bar exam. And it's a bar exam course, costs like $2,000 at the time. I'm sure it's more now. And it's just 2 months of total immersion. Then you take the bar exam. And I had to go down to Tucson to do that. I guess 1 year they do it in Phoenix, and the next year they'll do it in Tucson. And as I said earlier, you have to know a whole lot of information very shallowly, and you have to take the review course. Don't skip through it. So you have to study for it the way they tell you to. There's no way to go back. In my opinion. Then later, I was really sick of taking exams by this point, and I worked as an attorney at my law firm for up in Scottsdale for 10 years. And somewhere during that, I took the patent bar. I didn't take it right away, and I really regret that. It's like, all of you just do it now, if you're interested in this. Or do it in law school. Don't come out of law school not having taken a patent bar if you possibly can, because life gets busy. I had kids, I was sick of taking exams. I had fatigue of being at school whatsoever, so I do regret not taking it earlier than I did. So I should have done that during this. And then getting the registration. Now, one kind of funny thing, this is a good thing actually, ever since Nixon was president, now ever since then, lawyers have a lot of ethics requirements. Apparently all this came out of the Nixon era. Read a book on it. Yeah, there's all these ethics requirements. So in order to get licensed in any state, they make you take an ethics bar, which is a pretty easy course or a test to take, but it's a separate test. And they do a real deep dive into your background, and I did know a couple of students who went all through law school, or two of them, all through law school, spent all that money, took the patent bar, passed it, but they couldn't get the ethics. They couldn't get past ethics. One of them was a pilot who lied on FAA paperwork about how many hours he flew to get his license. You lie on your taxes, parking tickets, they don't care about that at all. I had a bit of a goody maybe, I don't know. But if you have any serious, if you've been convicted of anything or, you've really got to sort that stuff out before you go to law school. Because what they'll do is they'll have a hearing, the Supreme Court of Arizona, they have an ethics board and they'll have a hearing to see whether they'll pass you or not. And it's with an ethics problem in your background, it's hard to get licensed. But oddly, if you become, an unethical lawyer during the time, it's pretty hard to get thrown out of the bar. So you think it would be easier to get thrown out of the bar if you're being a bad lawyer, but most of the time that's just a discipline thing. So the rule is always keep your money separate from your clients and tell on your friends. So any questions about this? And this is, can be different for so many people. This just happens to be the way I did it.
How do you imagine your career would play out had you not gone to that, had you not crossed the streets that talk and all that?
I probably would have tried to just get a job as a bench scientist at a company. So I think I was floundering quite a bit because I just love science and I, liked doing that bench work, but I just didn't know enough about what to do after that. And I never had talks like this given to me ever. I just, stumbled into them. And I was really lucky that I went to that one, happened to be there that day and went to that one, forensics in the law. And what kind of kills me is like, why didn't the Center for Law Science and Technology come over across the street to us, where we're full of PhDs that are doing postdocs at biodesign, and all over campus for that matter, and tell us about them.
Don't talk to them.
That's the way ASU has always been. The departments never talk about each other, right? Yeah. And how hard up they were for PhDs, it's like, we're all over there. Come get us. We don't know about you. So. Okay, my pros and cons list. Oh, I was worried about not taking up an hour. So I just kind of did a simple, I actually thought about this for a long time. Some cons, expensive. ASU law is actually really cheap, 90 grand. And that's just tuition. That doesn't include books and living and all of that. And another con, not really a con, could be in the middle between pro and con, is that law firms are businesses. And that's only one area that you could end up, you could be at a company, like I had that list earlier about all the different places a patent attorney could be. But when you're in a law firm, and I've only been at law firms, they are businesses. You have to bill a certain number of hours for them to give you the salary. But the salary is good, the benefits are good, 401k matching, all that life stuff, health insurance, they're good jobs. So, and they know to be able to attract, the talent, the background that they need for their client base. They're going to have to offer those things or they're just not going to get employees. Law firms always seem to be hard up for PhD JDs. So, they're all over LinkedIn. They're, that position is in demand. I've been able to easily find jobs because of it. The salary and benefits have been good. And now that I'm, like I said, now that I'm experienced past now that I'm 14 years experience, I would say maybe even past 8 years or so, I can work remotely. I can move to Hawaii if we want to, and I can still work for my firm, which is cool. It's nice to be located in the Southwest though, because I like to visit clients and I like to see people, go to conferences in person and, have some FaceTime. So that's what, and so flexibility to practice other areas of law. So when you have your law degree, it's a really versatile degree. Some people go to law school and they never even practice law. They never even take the bar because they want to go advise, a think tank in Washington, DC or something, and they just need to have that law background to do that. What I did is I wanted to feel like a legit attorney, even though I'm a transactional attorney. I didn't like the feeling of I've never been in court. There's a scene in that A Few Good Men where Tom Cruise is just I stood up and made the argument. That's what I kind of felt like. I wanted to be able to do that, but God, no, I don't want to be a litigator or a patent litigator. So what I did was I went to work for my friend in family law just as a side thing while I was still doing the patent law thing. I got my boss to agree to it. And I just took a few cases and I represented some families in family court to child support. One had a son who was having a drug addiction problem and they needed to get him out of his environment and into a school in Georgia or something. And his mom didn't like that. 5 minutes. Okay. So anyway, I went to court and I made that happen. And, it takes the mysteriousness out of court. Court is intimidating and kind of scary, but, get in there, rip off the Band-Aid and realize, I could talk forever about court. And also the smartest people you'll ever meet are judges. Hands down. No one will know the law better than judges. They are, one tax attorney told me, judges are the A students, prosecutors are the B students, and private practice are the C students, and they make all the money. So judges, at least the judges part, very true. They don't mess around. The client respect appreciation part is nice. The CEO of a company will stop what they're doing and come talk to you because what you're doing for their company is that important. The professor of the lab will stop their meeting and come talk and pick up the phone to talk to you. And that's, that kind of respect is quite nice. A high level of professionalism. I don't have any work politic bullshit. Am I allowed to say that?
Sure.
There's no petty garbage. We're all too busy. And I enjoy that higher level professionalism. And I'm sure that it's mostly like that for you guys now. The higher you move up in, education and responsibility, that kind of stuff falls away. But I've never had patience for it. So that's one thing I enjoy. And you can be a partner in a law firm. You can start your own law firm. You have the ability to be independent this way. You can be self-employed. You can be an independent contractor. I'm a contractor, not consultant. So, there's some flexibility to get out of the rat race, and do things on your own terms, hang out your own shingle. That's what my boss used to say. I think I better kind of stop there, but I'm happy to keep talking as you like.
Don't you last one thing?
Oh, right. Oh, yes. Okay. What's the movie? Thank you. Everybody remember this one? Was it Armageddon? Yes. Billy Bob Thornton and Bruce Willis. And one of the lines in the movie when they have already built his drill, and Bruce Willis didn't know that they built his drill, which he's patented. He's like, "Would you steal the key to the patent on this?" And that's again one of the wrong things. It's totally public, as long as it's not a national security type of subject matter in the patent, it's all public. So, and because I am an IP attorney, I have my proper copyright notice on the bottom. Thank you.
Well, I see that John already has his hand raised down there.
And we take a couple of
Yeah.
questions and you're all gonna have time. Let's say
Also-
Tom's first.
I'm gonna put out,
Oh, yeah, please do.
not because I think you'll become clients, but because if any of you really think you're interested in this, I'm happy to talk to you, email you, whatever you like.
John, can you hear us? Want to try to say it, or you can either type it or say it?
You hear me?
Mike,
Oh,
yeah,
hang
you
on.
might need to type it.
Okay.
Or it might be in the chat there. Yes, the chat should be here. Oh, let's get that quick. Well, while we're waiting, Julie, why don't you go ahead? Yeah. And I'll go best and see if I can.
On happening stock.
Oh, I know.
Oh, and I just, in a few years, I was wondering.
I believe a lot of software does get patented. There's definitely been a lot of case law that have come out narrowing it down. They want to make sure that it's not a law of nature, sort of the way mathematical formulas are. That it, you know, that the software is doing something above and beyond the normal processes of a computer or something like that. I'm not a software patent attorney, so, patent attorneys are all very specialized in their technical areas. So if someone came to me with software engineer, I'd be like, hey, talk to my friend John here. You know.
I think it's gonna be similar because I missed your question, but it sounded like the conversation. At what point does software dealing with laws of nature become patentable? Yeah.
Probably not the person to ask about that, but software, I mean, a lot of software has practical applications, you know, like diagnosing things and those things are patentable.
So I'm gonna call class officially. So if those of you online want to chat, that's fine, but we got a couple more questions. If you're good with sticking around for a couple minutes, we might as well take them.
The cost range for if you wanted to have a patent or an idea or something, what is that range?
So that range can be, so there's the initial filing of the application where a lot of the work is, you know, just writing that thing that looks like a dissertation. That can be anywhere from $10,000 to $25,000. I did one that was $60,000, but that's unusual. So usually it's 10 to 12. For chem type things, it tends to be more around 12, because there's so many figures. A lot of times, 80 figures. Where's the other one?
Run over when you get that number.
But that's, I mean, you have to be prepared to spend, because there's the whole prosecution part, there's the initial filing, and then there's a filing fee of about $1,000, and that's just US. If you file internationally, like make a placeholder application, it's called a PCT application, that's like $2,500 filing fee plus, you know, the say, we'll call it 10,000. And that's just to get it on file. And then, like everything in life, you get rejected, you know. From the patent office sends you a rejection and says, you know, we're not gonna issue these claims because we think, you know, something's indefinite, or you didn't word this right, or you don't have support for it in your application, or all these references that we found make it so that you're, you know, what you're trying to claim is not new and it's obvious and you know what's been done before. Excuse me. So then you have to do all that arguing, and every one of those steps costs $2,500 to $5,000. At any one of those times, a client may say, this is too much for us, we're not interested anymore. The licensee dropped out, stop prosecution, and then you kind of cut it off right there, or keep them. So if you're like an entrepreneur, you know, graduate student, you spin off a company, usually they have to get, you know, investor funding to get the people. Or the university will at least file the first provisional application, but that's like a placeholder application, which only costs $120 file. Might be $135 now, it's really cheap. Doing the work part might be like $2,500, but the patent attorney will just spend, you know, 4 or 5 hours on it and not really out.
John Logan, Dylan, and then Bruce.
everybody remember lunch again today, and then if anybody's interested, I think it's gonna be meeting with Vanessa after this, or by my office, and you're welcome to come join there too.
Yes. Pretty tough, it's really interesting. I'm just wondering, after you've had something, at what point of the process you can make a profit? It's part of the license process, or it's just when you something, I don't know.
That's such a big variable, that's, you know, really specific to what the patent's about and how good of a business person is, let's say, running a spin-off company, or how good the IP managers are about getting a license. And then maybe it has to go through FDA regulation first, you know, before you can start selling those. Yeah, there can be milestone payments from license. That if they capture exclusivity for your patent, they have to pay you to get exclusive, you know, so that could start pretty early. Geez, starting to make money, that's a whole other thing.
No,
So the requirement for a patent useful. That be useful to one other person or does it have thousands?
It's not to the people, it just has to have a utility. So and I think of that as kind of being the opposite of being ornamental. So like copyrights can be, you know, often something ornamental, design patents actually. Ornamental things. But yeah, utility patents, so we normally get more utility patents, and they have to have some kind of useful purpose. So it's a really low bar, you can produce anything. But it has to be something more than ornamental. I've never gotten a rejection for the lack of space. But I do get rejections all the time for lack of novelty, lack of lack of non-obviousness. And it's rarely a law of nature because that often means claims weren't drafted properly. But you know, very rarely do I see that kind of rejection. It can happen.
I think we have a room now, very intrigued, burgeoning.
Not too many of those people who want to go to law school.
Let's stay there. And then again, any questions, usual schedule folks, right? So lunch, but if you want some extra time again, right?
And again, if you get asked a question there, maybe you notify.
Yeah.
Was awesome. That was awesome.
I don't think they got bored.
No,
Sorry, I got really hot.
I want to have work for you. It's like, as much as you're interested, there is an audience.